If you're a landlord or tenant in Ohio, it's in your interest to understand the state's rental laws. Whether you're at the beginning of a lease and want to know how much can be charged for security deposit, or nearing the end and have questions about the eviction process, knowing the law is the most cost-effective way to protect your interests. We're eForms, the world's largest online database of fillable legal forms. In this video, we'll address Ohio's rental laws, including the different kinds of leases and what they mean, the state's specific rules regarding security deposits and other landlord obligations, and Ohio's rules regarding evictions. Searching for a lease agreement that complies with Ohio's laws but is tailored to your property? For a step-by-step guide with creating one, click the link at the end of this video. In Ohio, as in other states, even before you turn to the laws, the first thing to think about is the lease itself. If a landlord or tenant has a question, in most cases the answer will be found in the written lease agreement, not in the state's laws. A lease agreement is a contract between a landlord and a tenant or tenants. That means that the parties can include or reject terms depending on their situation. Ohio has many different kinds of leases, but for residential property, the most common is what's known as a standard lease, in which the landlord and tenant agree to a property that will be leased for an entire year. Once the year has ended, standard leases often automatically turn into month-to-month leases, which can be ended by either party simply by providing adequate notice. Ohio law requires a 30-day notice to end a month-to-month lease. Like some other states, there is no maximum for a security deposit in Ohio. However, if a landlord does demand a security deposit greater than $50 or 1 month's rent, there are several requirements that can come into play. The landlord must keep the security deposit in an interest-bearing account. If the tenant is at the property for more than 6 months, any interest earned becomes property of the tenant. And when the lease concludes, the deposit plus interest must be returned to the tenant within 30 days. If any of the deposit is retained to fix damage to the property, this must be explained in a written itemization. In most types of properties, Ohio landlords are responsible for ensuring that a unit has running water and reasonable heat. And if a property has more than 4 units, it is the landlord's responsibility to maintain a dumpster or means for waste disposal and hauling. A landlord in the state is allowed to come onto the property, but except in cases of emergency, they generally must provide at least 24 hours notice to do so. Ohio's rental laws also establish procedures for eviction. An eviction is the legal process for ending a lease and returning a property to a landlord's possession. It can occur when a tenant has violated a provision of the lease, and in Ohio and every other state, must be pursued through the courts. The first step in the process is providing tenants with a notice to quit, which gives tenants a certain amount of time to correct a violation of the lease or leave the property. In Ohio, most lease violations, such as failing to pay rent on time, require only a 3-day notice. If the tenant is failing to comply with some part of the state's health and safety code, the tenant must be given 30 days to correct the problem or leave. If the tenant fails to respond or fix the problem within the notice period, the landlord can begin the petition to the court to evict the tenant. Keep in mind that every county in Ohio requires using its own specific forms for the eviction process. You can find more information about specific aspects of Ohio's rental laws in the links in the video description, or for more videos on related topics, click the subscribe button.